Production and distribution of City Club Forums on IdeaStream is made possible by the generous support of PNC and the Raskin Family Fund, with additional funding from Cleveland State University, Robert Conrad, and the Payne Fund.
Good afternoon and welcome to the City Club of Cleveland. I'm Ann Owings-Ford. I am an attorney and president of the Cleveland Metropolitan Bar Association. Together with the Bar Foundation, we are proud to partner with the City Club of Cleveland to present a Law Day Forum every year. And we're delighted to welcome our speaker today, Cait Clarke, Chief of Defender Services at the Administrative Office of the United States Courts. In other words, she is the federal defender in our nation. This Law Day, which falls on Sunday, May 1st, we recognize the 50th anniversary of the U.S. Supreme Court's decision in Miranda versus Arizona, which requires law enforcement officers to safeguard the Fifth and Sixth Amendment rights of the people they arrest. These days, thanks to Law and Order and other police procedural dramas on television, if I asked you to Mirandize the person sitting next to you, you would begin by saying, you have the right to remain silent. You have the right to an attorney. Anything you say can and will be used against you in a court of law, and so on. This is a good thing. But rights like these don't mean much unless we know and understand them well enough to exercise them. And today, in the age of social media, exercising the right to remain silent is more complex than simply not speaking. So we are honored to have Cait Clarke here today to provide more context and a deeper understanding. Ms. Clarke has been with the Federal Defender Service since 2013. Previously, she was the Director of Strategic Initiatives for the National Legal Aid and Defender Association. She has trained at Harvard, Georgetown, Catholic, and Villanova universities. Ladies and gentlemen, members and friends of the City Club, please join me in welcoming Federal Defender Cait Clarke.
Thank you. Thank you and good afternoon. And thank you for this very warm welcome. Nooper, you are fantastic. I hope you do go to law school and become a federal defender. And I want to also say what an honor it is to meet Judge Capers, who's here. Thank you so much for picketing long time ago. Right, and I am honored to be here. Thank you, Ann. Ann Owings-Ford has been more than gracious, and as the president of the Cleveland Metropolitan Bar Association, it's really an honor to have spent a few hours or an hour with her. And I said, everybody I've met is a truly amazing spirit and high energy, so thank you. And Becky McMahon, the CMBA's executive director, for bestowing upon me this privilege and honor of being this year's Law Day speaker. Mr. and Mrs. Maltz, thank you so much for all that you do, not only supporting the wonderful programs and educational opportunities, but as we spoke, thank you for helping DC. And I'll do whatever I can to help you. And thank you to Dennis Therese for arranging my attendance here today and for all of your strong federal defense work through the years. And thank you to all the City Club members for your being fierce advocates of engagement. One more time, fierce advocates of engagement. That is a wonderful, wonderful statement in our democracy. I also want to thank Dan Multhrop. Where is Dan? There you are. An amazing spirit who showed me the history of this club and intimidated me thoroughly before I stood up, knowing that presidents and Rosa Parks and Robert F. Kennedy and Bill Clinton and Bryan Stevenson, one of my heroes, and the presidents have stood here. So I'm truly humbled to be here, and I will try to make sure that I provide a small voice about two amendments that I care very deeply about, the Fifth and the Sixth Amendment, on this law day. I also want to just note, because I am a lawyer, is that my position is called Chief of the Defender Services Office. And what I think is interesting is that I am a public servant and I serve the federal defenders. So what that means is that in our country, we have 81 offices with federal defenders and community defenders and panel attorneys, over 12 to 13,000 panel attorneys that are paid on an hourly basis to represent people charged with crimes in the federal courts. I see myself not as the chief defender, I see myself as the supporter. I am the administrative office chief, and I am really honored to be a servant leader. So I just wanted to clear up that I'm also sure, right, Dennis, the defenders would be pretty upset if I was called the chief of the chiefs. However, I do run a very large organization that is the plumbing, the infrastructure, we keep the lights on. So I'm going to come at this law day with a perspective that is based on two areas. One being I worked in the state systems, including Ohio. My family's from Dayton, Ohio. Half of my family, the other are coal miners in Pennsylvania. So I come from the Molly Maguire background and a family that started a company many years ago in Dayton. So I come from that approach to saying, what is it in our states that we can do to protect individual liberties? And the second is that I want you to know that I've been working in the federal defender system through sequestration and other issues that have challenged our right to counsel. We lost over 500 employees between September 13 and March. 500 is a lot of people who fight for our individual liberties to have lost their positions. So we're trying hard to build back. So that's the context within which I will make my remarks. Also, as a mother and a person who's very proud to be standing here as an American woman speaking to this esteemed group. So the theme of this year's Law Day in the United States Supreme Court is a 1966 decision. I was 6 years old, born and raised in Washington, D.C. when the Miranda decision came down. Miranda versus Arizona gave us the famous Miranda warnings. We can all recite them by heart. Before we get to Miranda, though, I'd like to say a few words about what brings us together on this Law Day, where hundreds across this country are gathering on Law Day. This is a quintessentially American tradition that began actually in 1957, when the American Bar Association president, a gentleman by the name of Charles Rhine, announced that we needed a special day to celebrate our legal system. In 1958, President Eisenhower signed a proclamation declaring May 1st as Law Day. Since then, every president has issued a Law Day proclamation to celebrate our nation's commitment to, and you know how to fill in the blanks, the rule of law. Congress also endorsed the idea by issuing a joint resolution in 1961 designating May 1st as the official Law Day celebration. It's now codified in the U.S. Code. I'd like to focus, though, on President Eisenhower's very first Law Day proclamation from 1958. In that proclamation, note that President Eisenhower didn't focus on civil issues. He said the principle of guaranteed fundamental rights of individuals under the law is the heart and sinew of our nation and distinguishes our governmental system from the type of government that rules by might alone. He and other presidents noted that we have a steadfast commitment to individual rights. Those rights, though, of course, include the rights of the accused. It is no accident that 4 of the first 8 amendments in the Bill of Rights set forth rights that belong to individuals facing criminal investigation and prosecution. Our founding fathers recognized the importance of protecting individuals against government abuse and overreaching, and empowering them to stand up against government that comes after them and threatens to take away their liberty and maybe even their life. Two of these fundamental rights are at stake in Miranda. The Fifth Amendment privilege against self-incrimination, which states, I'm sure you all know it, no person shall be compelled in any criminal case to be a witness against himself or herself. And the Sixth Amendment right to counsel, which provides, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. If these two rights are recognized in the famous warnings that are now so embedded in our culture, we must be thankful to the media, thankful to TV shows and movies and the like, and the press, because almost everyone in America can recite that famous holding. Anne took a little bit of my interactive method here. I was going to ask people if they could recite the Miranda warning, so I will jump to putting it on the screen. If anybody knows the Miranda warnings, I don't know if you have ever given your children a card like this to put in their pocket, but I have a young teenager who is a wonderful child of color who is Mayan Indian descent, very, very sharp, and he knows the Miranda warnings, and he asked before I got on the plane last night as we were watching Treme, Mom, if they stop me, do I give them the Miranda warnings or do they give them to me? And what shall I do? Do I answer any questions? And I said, call your mom. So a few questions to ask, and then I'll have three parts to my remarks. Are these more than mere words? Is this just a catchy phrase? Are these catchy phrases that we hear often? No. These words embody our country's core principles, that everyone has a right, and these rights must not be curtailed no matter how noble the cause. Our nation's commitment to and protection of these fundamental rights has not always been steadfast. We have had to fight diligently to protect these rights. We have to protect the accused, who aren't always people that we like. Many of those fights have taken place in the courtroom. And indeed, every day, public defenders across state, county, and federal systems carry out their duties zealously to advocate for their clients. They don't call them the offenders. They presume they're innocent, and they call them their clients. As chief of the Defender Services Office, I have the responsibility of overseeing our federal public defense program. As a program, our mission is to ensure the Sixth Amendment right to counsel, the very right referenced in the Miranda warnings, has meaning in our federal courts. We strive every day to make sure that everyone charged with a federal crime has high-quality representation consistent with the best practices of the legal profession, regardless of their financial means, regardless of their zip code. Our federal defender program was in its infancy at the time of the Miranda decision and has since developed into a strong hybrid system that is much admired around the world. We now have 81 institutional federal defenders that in total employ over 3,400 lawyers, investigators, paralegals, and support staff, including mitigation specialists and mental health experts. We are dedicated to serving clients in 91 of the 94 federal judicial districts. We also have 12,000 plus private panel attorneys who accept appointments from the courts to represent individuals charged with crime, often when there's a conflict of interest with the Federal Defender Office. So they will take the others charged in the case. Together, this hybrid system provides quality representation to a vast majority of individuals who are prosecuted in our federal courts. And sometimes you'll hear the words indigent offense, but frankly, many of our kids and some of us might even qualify, because to be represented in federal court in a major case is quite costly. It is truly inspiring to watch our federal defenders, our community defenders, and they are executives of community defender offices run by a board of directors, and their staffs dedicate themselves to representing individuals. Their advocacy ensures the government does not abuse its tremendous power and helps protect all of those so that we avoid wrongful convictions and other injustices by fighting every day. And yes, sometimes it is a fight, or it's often a fight in the courtroom and outside, to ensure that the rights are brought forward, like the Miranda warnings, are brought above the radar, and that these defenders are playing an active role, upholding the ideals of President Eisenhower and others. They protect all of those proclamations that are sent out today on Law Day. So that's not to say there aren't challenges. One thing has never faltered in the dedication of the people who do this work. What I'd like to do is focus on 3 areas. Miranda decision is the context. I'll focus on, first, the past. We can't understand where we are now without understanding where we've been. That is why hate speech and addressing what we heard today is so critical. Know where we've come from and help us move forward into the second area, which is the present. I'll give you some information about the current system in our federal courts and the challenges we face. And then third, I'll conclude with, finally, the future. What is the future of Miranda? Is Miranda enough? What else should we be doing to safeguard the rights of the accused, including the Sixth Amendment? So let's rewind time for a moment. Before there were Miranda warnings, most people had no idea what their rights were. An individual could be taken into custody, cut off from access to their family, their friends, questioned alone by multiple government actors with no explanation of their rights. They certainly did not understand they had the right to an attorney. Even today, most people think the right to counsel, the right to an appointed lawyer, did not exist until the famous decision of Gideon versus Wainwright in 1963. But that's actually not true. In fact, the right to counsel, or the right to be represented, goes all the way back to, on your beautiful mural by Mr. Brown, the Magna Carta is up there on the far right. If you look to your left afterwards, that is an outstanding mural here. It goes back to actually also our colonial times. The U.S. Supreme Court declared effective court-appointed counsel to be a constitutional right in capital cases. When I mean capital, of course, that's the death penalty in Powell versus Alabama in 1932. And then 6 years later in Johnson versus Zerbst when the court finally said counsel is a right in all federal criminal trials. Though these rulings are significant, they remained a major problem. There was no funding and no structure to support the exercise of this constitutional right. Words alone aren't enough. They're important, but they're not enough. Lawyers who were appointed to represent someone accused of a crime were expected to do this, you can fill in the blanks, pro bono. They were not paid for their time or their expenses. In 1962, just a few years before the Miranda decision came down from the Supreme Court, 2 Harvard Law Review editors researched the state of indigent defense and the practices that were happening in federal court. What they found is when they conducted surveys is they talked to federal judges and lawyers all over the country. In a typical case, a lawyer's role was, quote, limited to appearances at arraignments and sentencing, discussions with his clients and a prosecutor, occasionally a brief investigation of the case to uncover mitigating circumstances. Oftentimes, a judge would be in the courtroom and say, Mr. Jones, in the back, I know you really do real estate law. Could you do this case pro bono? Most people reported that assigned counsel typically spent, quote, less than 3 hours in out-of-court preparation. If a client pleaded guilty, quote of the survey, a hurried 10-minute conference in the corner of the courtroom was often the sole prelude to a guilty plea. Despite these findings, the vast majority of judges and lawyers surveyed thought the quality of representation being provided was sufficient. 93% of those surveyed thought that the thoroughness of assigned counsel's preparation was adequate or very adequate. Not adequate. Fortunately for us, the leaders of our country, they gathered and they realized that we must recognize this right, formally, structurally, and give more meaning to those words. President Kennedy, in his last State of the Union address, was the only president to have mentioned the right to counsel in criminal cases. His words were, "The right to competent counsel must be assured to every man accused of crime in federal court, regardless of his means." His brother, Robert Kennedy, as you all know, the Attorney General at the time, and the former guest here at the City Club, who spoke, I believe, the day after Martin Luther King was murdered, quite composed and a powerful speech. Robert Kennedy made it a priority to provide adequate representation in indigent defense. Imagine that. The Department of Justice made it a priority. Testifying before the Senate Judiciary Committee, he explained, "To a serious extent, the scales of justice in this country are weighted against the poor. Each year, thousands are confronted with obstacles to obtaining justice because they are financially unable to obtain an adequate defense. Our courts are continuing to delegate the defense of underprivileged to the assigned counsel, lawyers who will not be paid for their services. They will not be reimbursed even for their out-of-pocket expenses. They will not receive a shred of investigative or expert help. They will not be appointed until long after the arrest, when witnesses may have disappeared or leads have grown stale. Defendants with appointed counsel, as opposed to paid counsel, had less a chance to get the charges against them dismissed, less a chance of acquittal at trial if they went to trial, and a greater chance, if convicted, of being sent to jail instead of being placed on probation." Sound familiar? A system which lets the lack of resources make such a difference is unfair to the defendants. It places an oppressive burden on private lawyers. It denies equal justice. It needs a correction. Thanks in large part to Robert Kennedy's advocacy and the advocacy of those in Congress, they passed the Criminal Justice Act in 1964, and the CJA created for the first time a system to compensate lawyers to represent defendants, and I say all defendants who could not afford counsel in federal court. Recognizing that good lawyering is not enough, the CJA provided for compensation in investigation, experts, and all of the resources needed for a necessary defense. Kennedy explained before the Senate. Again, remember, he's the Attorney General. Providing for experienced paid counsel is fundamental, but the phrase adequate defense means more than just counsel. Equally important to a defense are defense services. For example, the poor man cannot hire an investigator to find the witnesses, the evidence which may be indisputable to his case. He cannot retain a physician, a psychiatrist, or handwriting experts. The importance of skilled investigation is underscored in the police work every day. It works the same way for the defense. It was that skilled police investigation that Robert Kennedy mentioned that was at play in Miranda. Historically, and much of the 20th century, police investigation could be brutal, particularly in certain parts of our country. The most basic protections afforded by the Constitution were often illusory in practice, especially for the poor and minority communities. Individuals accused of crime were often were coerced into confessions that were not necessarily unusual, but they were not rampant. I want to be sure that we understand. We do believe in a strong and ethical prosecution and police work. It's very critical to an adversarial criminal justice system. Coercion was not acceptable. It was not acceptable in court. To be admissible, a confession had to be voluntary. And courts would determine voluntariness based on a case-by-case basis, looking for all the circumstances, a holistic approach to finding out whether it was voluntary, And the interrogation, the length of the interrogation, the individual's characteristic, their age, perhaps their mental capacity, that would all be taken into consideration to see whether this was a voluntary confession. Around the middle of the 20th century, police started to use other techniques to obtain confessions. We've learned a lot about the brain and stress and mental and psychological tools. Psychological pressure and deception became more common. This led to confessions that, while not compelled or coerced with physical force, they were still involuntary. Courts had to grapple with the question of how these police interrogations should be regulated so that the individuals, their constitutional rights and safeguards, yours and mine, were not infringed, and that incriminating statements would not be admitted. We wanted confessions that were products of free choice. That was the question posed in Miranda. The court ended up adopting a very pragmatic approach. In a 5-4 decision, the court outlined specific ways that the law enforcement officers must read these before interrogating anyone in custody. Note those words, anyone, before, custody. All of those words have been litigated, as you're not surprised. What does it mean to be in custody, right? The court also held that if the warnings were not provided, the prosecution could not use any incriminating statements in court unless it showed that the individual had waived his or her rights. The decision certainly had its critics. Many thought it stilted the system too heavily in favor of the accused, unfairly tied the hands of police who were trying to solve crimes. But according to several studies that have been done since Miranda and over many years, in the wake of this decision, the warnings have not, in fact, interfered with police forces' ability to do their job. Instead, some argue that Miranda warnings actually improved law enforcement because they enhanced public confidence in the system, and it gave more legitimacy to the confessions that did result. Part 2, Miranda today. Those warnings are embedded in our culture. You see it all over the media. Though the words remain the same, what's different is the context within which they operate. At the time of Miranda, most crime was dealt with at the state or local level. In Miranda, the decision itself, there's an interesting footnote by Chief Justice Warren. He listed those federal crimes that fell within the enforcement jurisdiction of the FBI. The list was short. May I read them to you? Kidnapping, white slavery, bank robbery, interstate transportation and sale of stolen property, conspiracy, civil rights violations, murder of officer or employee of the United States. That was the list. There were probably a few others that did not make the Chief Justice's list, perhaps because they did not yield many cases or require significant resources. But that's the list at the time Miranda was decided. What does it look like today? Today's federal criminal code looks very, very different. One report estimates by the end of 2007, the U.S. code includes over 4,450 federal crimes. And that's not even counting criminal offenses outlined in the Federal Regulatory Code. Practitioners, academics, and even the Department of Justice have struggled to document the actual number of federal crimes. Along with the expansion of federal crimes came the expansion of federal agencies to investigate these crimes. So, our offices, I believe, as you all know, there are investigators on staff, maybe 1, 2, sometimes larger offices have more. Who investigates for the U.S. attorneys and assistant U.S. attorneys or special assistant U.S. attorneys? Anybody know? The FBI. Anybody else? The Inspector General. Anybody else? ATF. Postal Service. Customs. Secret Service. Okay, so I know that you're dying to see this slide. So here's what we've got. These are some. of what I'm showing are the badges, and I'll read the names of the badges you just saw. So remember, these are the investigative units that support charging in these federal crimes. Bureau of Indian Affairs, the Alcohol, Tobacco, and Firearms, for those of you that don't know, ATF, DEA, Drug Enforcement Agency, ICE, Immigration and Customs Enforcement, the Department of Homeland Security, Postal Inspectors, Department of the Treasury, Social Security Administration, Fish and Wildlife, the Secret Service, the U.S. Marshals Service, the U.S. Park Police, and local task force officers as well. These agencies investigate and build cases sometimes over the course of years against one individual. Not only are there more crimes and more agencies investigating those crimes, but the stakes are higher. The 1980s and the 1990s saw the introduction of mandatory minimum sentencing and rigid sentencing guidelines. Federal criminal charges today carry very serious consequences, and therefore they create enormous pressure on the clients or defendants. Our plea rates now in some areas are pushing over 97, 98%. That means very few go to trial. What does all of this mean for the individual under investigation or charged with these crimes? Well, the Miranda warnings remain critical. They are important. They're essential that law enforcement continue to inform people of their rights. But the warnings alone are not enough to safeguard the rights of individuals, especially those who are vulnerable. Those individuals who may not even understand or comprehend the warnings. Studies show that many of our most vulnerable populations, juveniles and the mentally disabled, to name a few, do not understand their rights when they are read to them. Cultural barriers can prevent non-citizens from comprehending these rights as they are stated to them. For example, a colleague of mine said in Mexico, for instance, the criminal justice system was always an inquisitorial system. It's shifting. But when for an accused person in that system, telling his or her version of a story is a part of the system. So what happens when that person or child enters the American criminal justice system? Even if told of the right to remain silent, he or she may not fully comprehend what that means. He's likely to think that by talking, he is just playing his part in the process. He may not understand that exercising his right to remain silent may give him a better chance at securing his liberty. Still, others have a deep-set belief that money buys you a defense, and if they have no money, no attorney can help them. This sort of thinking leads to some to waive their rights simply because they don't fully comprehend them. These sorts of cultural issues are a challenge in every court, not just the federal court. In the end, we have a system where individuals who need counsel, the ones who most need it, are the least likely to ask for it. So, anybody know of the Central Park jogger case? Do you remember that back in the late 1980s? If you could take a look someday at, Ken Burns has a documentary that's very powerful called The Central Park Five. This documentary is about the notorious 1989 case where 5 Black and Hispanic teenagers were convicted of raping and beating a 28-year-old woman who was jogging in Central Park. It was the modern-day Scottsboro case. This was the 1980s in New York City, and the then mayor called it the crime of the century. The teenagers, who ranged from ages of 14 to 16, were in the park that night. But none of them were involved in the brutal attack. As one described in the documentary, I went down to the police station to tell the story that I was running with the folks in the park, and I came home 13 years later. After hours of psychological pressure and aggressive interrogation by seasoned homicide detectives and repeated Miranda warnings, they each ended up giving false confessions. These false confessions were put on video. Their parents were often in the room. Their parents were told the Miranda warnings. These confessions were used to convict them, and they served as much as 13 years in prison for a crime they did not commit. It was only after the actual attacker saw one of the older alleged perpetrators in prison and apologized to him. He thought he was apologizing to him for a spat they had had in another prison, and he didn't realize he was apologizing for taking the charge and serving time. So it was that confession by the actual attacker who went on to kill. He confessed years later, and their convictions were overturned. The men were released, and in this documentary, it does a wonderful job of telling the story from the teenager's perspective. How did the public pressure come to bear? And they blame the lawyers, the defense lawyers, the press, the public outcries. There were even calls by some to bring back the death penalty for these 5 young boys who were innocent. How can this happen when we have Miranda, when we have Gideon, the right to counsel? We have a federal public defender system. Where did the careful investigation and deliberation go? One of the jurors said he was holding out because there was no DNA evidence and nothing matched, and he thought these kids had been, these were false confessions, and he said he just got tired and wanted to go home. So he gave in. Well, many people believe they could never confess to a crime they didn't commit. False confessions are one of the leading causes of wrongful conviction. The Innocence Project has collected numerous stories and data about people who have given false convictions, even after being Mirandized several times. Let me just read to you, in the documentary, there is a social psychologist. When asked, why did these kids, they didn't just admit to, I was there and I was a part of the, remember it was called wilding? They actually gave facts that, and people just can't believe they confessed. And a social psychologist, Saul Kassan, says, quote, confrontation followed by denial, followed by you're a liar and I want to hear the truth, can go on for hours. And the goal there is to break the suspect down into a state of despair, into a state of helplessness, so that the suspect gets worn down and is looking for a way out. One of the boys, Anton McCrae, said, they pulled my father aside, and when he came back into the room, he just changed. He's like, listen, tell these people what they want to hear so you can go home. If he would have stood his ground, if my father would have stood his ground, I would have told the truth and stuck to the truth. It's also noteworthy that Miranda does not prevent officials from using deception or trickery in the interrogation room. Some suspects may be told that they will be convicted with or without a confession, but that a confession will guarantee them a more lenient sentence, or that a confession is the only way to avoid the death penalty. I want to note again, there are outstanding ethical prosecutors and law enforcement officials throughout our country in the county, state, and federal system. But these problems persist. All of this begs the question, so what can we do? Part 3. The good news is Miranda warnings are here to stay. And as we mark the 50th anniversary of that historic decision, we have to ask ourselves, are they enough? Do they go far enough? What structural protections can we put in place to protect our family members? Some states require that all interrogations be recorded. And in 2014, the Department of Justice announced that adopting a policy establishing the presumption that the FBI, DEA, ATF, and Marshal Services will electronically record interviews of suspects in federal custody. But note, remember, in the Central Park 5, they did have a recorded video. And of course, there are some exceptions, and the U.S. Attorney and FBI agents can override the policy if they have good cause to do so. So, Miranda stopped short of requiring an attorney to be present at every interrogation, but law enforcement does not mandate that this, or does the Supreme Court mandate that we have these policies, but they can go further on their own, and many organizations have. Having a lawyer present may not necessarily prevent all false confessions, but at least it helps keep things in check and levels the playing field. Of course, the defense lawyer's role does not end in the interrogation room. I ask you, as you look to the calls within this next election, in the criminal justice system, questioning, is it fair? The scales of justice need to be rebalanced. We need to make sure our public defenders have the resources they need to investigate the facts, interview witnesses, and, of course, test the government's case. We must guard against inherent abuses that might arise. I ask you that I know there will be lots of work going on with the RNC here in July. The leaders of the country will be discussing criminal justice reform. I want to note that we need to have public defenders present. I talked to friends who were involved with the Ferguson situation when they were trying to do criminal justice reform, and it was a lot of law enforcement and police and prosecutors and public defenders need to have a place at the table. So as the Chief Justice John Roberts, our current Chief Justice, wrote in a recent opinion, as I conclude, an individual facing serious criminal charges brought by the United States has little but the Constitution and his attorney standing between him and prison. He went on to say that in many ways, the Sixth Amendment right to counsel is the most precious right a defendant has because it is his attorney who will fight for the rights that the defendant enjoys. It is the one standing between him and liberty. That attorney cannot do so unless he or she has the training, time, and resources necessary. So these goals are not new. We've heard them. We've heard Miranda before. It's time for us to put some meat on the bones. It's time to ensure that we ask every time there's a discussion about criminal justice reform that you ensure those who represent the individuals have a seat at the table. The next generation, who we heard earlier, they have perspectives that are unique. The defense lawyers have unique perspectives of their clients, of the communities, of the people, and those they serve. Law Day is an occasion to pause and reflect on these core values. It is a celebration of our values. It makes us proud of our American justice system. It is unique and admired around the world. Returning to President Eisenhower's Law Day proclamation, it states, "It is fitting that the people of this nation should remember with pride and vigilantly guard heritage of liberty, justice, and equality under law, which our forefathers bequeathed to us." It's good to remind ourselves that we are a nation that tolerates and goes beyond just tolerating liberty, justice, and equality. Yes, we are all fortunate to hear the words, "You have the right to an attorney. If you cannot afford an attorney, one will be provided for you." I want to thank all of you for your time, especially the Cleveland Metropolitan Bar Association and the City Club of Cleveland for hosting this special event and for allowing me to share some thoughts about our justice system on this important day. I'll be happy to take questions, but please don't forget, you have the right to remain silent.
Today, we are enjoying the annual Law Day Friday Forum featuring Cait Clarke, Chief Defender Services of the Administrative Offices of the U.S. Courts. We're about to begin the audience Q&A. We welcome questions from everyone, City Club members, guests, students, and those of you joining us via our webcast. If you'd like to tweet a question, please tweet it at the City Club, and our staff will try to work it into the program. We want to remind you that your questions should be brief and to the point. Holding the microphones today are Content Associate Teddy Eisenberg and Office Assistant Wesley Allen. May we have the first question, please?
Sure, I'll kick it off. Hey, Cait, thank you so much for being here today and helping us mark another Law Day. When you talk about the rule of law and you talk about the Sixth Amendment and the right to an attorney, there still seems to be this culture among lawyers and among the general public that it's abhorrent to represent the worst of the worst. And I was thinking of a recent New Yorker article profiling Judy Clarke, who represented Johar Tsarnaev. Can you talk about that a little bit? I mean, that's very much central to the work that you support in your role, and the challenges inherent there, and the challenges for our broader culture and our broader community.
Right. I'm happy to. I call that the cocktail party question. How can you represent those people? And I think every public defender and federal defender has those questions, and it's a very important question. There's been a lot written about it, but I want to say that I think every defender who joins that community of representing some good people, some innocent people, and some very bad people who've done some bad things. I think you should know that one of the motivating goals is that within our adversarial criminal justice system, it's critical to bring the humanity to the system. It's critical to show the person, their flaws, their background, their culture, their interpretation of what happened, how they got there. And I think that we would be, as a country, losing ourselves if we didn't allow the humanity to come into the courtroom and bring voice to the voiceless. That's our job. Our job is to make sure that person has their day in court. And I know that a lot of people are also motivated in a different way. I tend to veer towards the humanity, that I am so proud when people represent people who've done really bad things but do a great job, like Judy Clarke and others. Day in and day out, they lose a lot. Do you know what it's like to go up every day and lose and lose and lose, but still represent someone who's done something bad and harmful perhaps? But the other important point is, a lot of these people are facing very serious charges that are being questioned right now. Our mandatory minimums are being questioned, right? The lengths of our sentences. We incarcerate many millions of people. Our dollars are spent on prisons that are huge operations. And I think it's important for us to note that the public defense system itself needs to be bolstered to bring the scales back so we can ensure that the process is an adversarial system, not an inquisitorial system or a plea mill. Sure. So I think we have to be very, very conscious that mental health is a major problem in our country. And if you talk to anyone who is working in the Bureau of Prisons or in state and county facilities, they will say, I'm working in a correctional institution, but I'm also working in a mental health institute. And we don't have the tools and the skills and the doctors and those to help us with the mental health issues that they're facing. So there was an example of a story of a colleague of mine who I have a great deal of respect for. Some of the offices around the country that are doing whole client representation, they're working with mitigation specialists and other experts, because when they interview clients, a friend of mine was representing someone in a death row case or death penalty case, and he said he had talked to his client for months and months about the case, preparing for trial. And it wasn't until he went up with his mitigation specialist, who had a master's in social work, that he said, I couldn't believe I was talking to the same person. The story came out in a way that he just connected to him, and he connected to him at many levels, because he said, I didn't realize that my client had never looked me in the eye. Never looked me in the eye, always looking down, and that there was a major mental health issue there. So this person knew how to talk to the client and then find out what was going on. So I'm not dismissing, please know, I'm not saying the whole criminal justice system is filled with our mental health patients, but I do think we've got to address what you see today with armed people going in and shooting all the time. I think there was recently an interview with one of the sheriffs who said, we just see too much of this and there's a mental health crisis in our country. So confessions and mental health are a major issue, and that's an example I would give. I also think juveniles, we have to realize that the frontal lobe has not developed. The decision-making frontal lobe does not develop until you're in your 20s. Probably some doctors in here who can be more specific than I am. But think of what you were like when you were 17 or 18. Enough said.
Ms. Clarke, thank you for your comments today. Criminal justice reform and sentencing reform. Can you tell us what needs to happen so that moves forward? Thank you.
Right. I want to acknowledge the U.S. Sentencing Commission, which is located in our building, has done an excellent job at looking at what has happened in the past, and they're trying to work with Congress and the judiciary and others. So I can't speak to the specifics, but I can say that at the state level and at the federal level, people are looking to mandatory minimums. And there's a great organization, Families Against Mandatory Minimums. You probably have heard of them. Addressing mandatory minimums is a critical issue. And one reason is because that earlier response, which is these are individuals, and it should be up to the judge's discretion once they hear both sides of the story. And judicial discretion is critical, at least in the federal system. And I think that's why in a post-Booker world, which said the sentencing guidelines were not mandatory, that it's important that judges and others in the courtroom understand the context and the human before them. I think it's going to take Congress, and a Congress that's unified to try to make major changes. And we will see what will happen in the next few years. But I am really pleased to hear criminal justice on the agendas of all parties. That to me has been enlightening, to hear people say we need to look at our criminal justice system. And sentencing reform is critical to that success. But also beefing up our public defender systems at the state and federal level and ensuring that they don't suffer what they suffered during sequestration. We lost 500 people already in a system that was under-resourced compared to the U.S. attorneys.
National security is at risk, possibly by a non-citizen of the United States as well. Yesterday at our museum in Washington, the International Spy Museum, we had several people that were quite involved with the issue of enhanced interrogation. They included General Michael Hayden, former head of the CIA and the NSA, Judge William Webster, former head of both the FBI and CIA. So the issue gets to be rather serious when we know that this foreign national is involved with an activity that will do great danger to our nation and to its citizens. And do we permit these agencies to involve themselves with enhanced interrogation?
Mr. Maltz, thank you for that outstanding question, and incredibly difficult question. I am going to say this, that as the chief of the Defender Services Office, we really want to make sure that those people, those individuals who are subject to enhanced interrogation, and I'm not quite sure what that definition is, but if they are subject to enhanced interrogation, that our federal defenders are called immediately. It's critical that from day one we have counsel present. I think that I saw that in the state systems, that the defenders would come in a little too late. They weren't there early on in the case to address and ensure that we have those rights protected. I'm not saying that interrogation should never happen, but it is critical to investigation. It's critical to our justice system. But I do think having counsel present is just as critical.
Do you know what, if anything, is being done to limit the practice of prosecutors overcharging in order to get a plea to a lesser offense?
No, I think that practice will always continue. Whether that's an answer you want to hear or not, I think that overcharging has been a part of our system for a long time. But remember, I used to teach negotiations for many years, and it's a common negotiating tool to put a lot of cards in your deck and have a lot to negotiate with. And then you can have your most desired outcome, and then you negotiate down to your goal. By overcharging, it helps the negotiations. And so people will say, well, I'll drop this charge, terrorism charge or racketeering charge for a plea. I do think we are doing it in the federal defender system. We are teaching people how to prepare a case to go to trial, but also in preparing for zealous advocacy, that means you have to be a zealous negotiator as well. And so overcharging, I think, will not go away. It's important for the prosecutors as a tool, but it is also sometimes because the law is not clear.
in terms of seeking justice, as the purpose of having the defense attorneys, what is being done to make sure they are prepared enough to be able to defend against someone who may have superior prosecutorial skills? In the case where, let's say, someone wants to grandstand because they know they have such superior skills and would work for other than justice.
Another excellent question and a difficult one to answer, but I will say from the Defender Services Office and the Administrative Office of the U.S. Courts, we have a training division that is quite outstanding, and we also have national programs. We have Sentencing Resource Council, we have a litigation support team, we have people who are experts in capital habeas litigation as well, and direct death representation. All of those players are very critical in that they need to continuously be communicating with one another and have the time to do their work. I think one of the biggest challenges we see is that we do need the resources to continue to investigate cases, because you know now it's not just about going out and taking pictures inside a yard or somewhere. It's terabytes and petabytes, I've heard, of information being sent in discovery. We will admit that there are new tools needed in terms of our litigation support team that need to come back into balance with the prosecution. We have a very good relationship with the Department of Justice on protocols. Our litigation support team works with them to make sure that when you're sent discovery, you can actually open it, and our lawyers are being supported in that way. I think it's the tip of the iceberg, though. We do know that in many parts of our country, our panel attorneys are working hard. We have panel attorney district representatives to raise the percentage of lawyers who hire investigators and hire experts. Right now, the data that I have is that in many jurisdictions, it is 15% or so of the cases that are paneled out that actually hire experts and investigators. So it's a problem. And I will say that our office and the judges who serve on the Defender Services Committee and the other judges in the Judicial Conference and others have been very sensitive to helping improve and support our training, our federal defender offices across the country. But we have to get people to investigate, and we have to get them to hire experts. Otherwise, we're just hearing one side of the story that has a lot of resources. They have a lot of resources.
I'd like to follow up on Mr. Malsa's question about the enhanced interrogation. There seems to be significant debate over combatants that are detained and suspects that are arrested. And there seems to be some who believe that the combatants are entitled to your office's support. Could you comment on that?
Yes. No, actually, I can't. I can say that personally, I believe, as I said, in the right to counsel from the very beginning, and that means anyone who is being targeted by the government, they should have counsel. I cannot speak for the Judicial Conference, but I thank you for that question, and I'm sorry. But I'm often asked very difficult questions that I can't answer in my position.
Today at the City Club, we've been enjoying a Friday forum, the annual Law Day, featuring Cait Clarke, Chief, Defender Services, Administrative Offices of the U.S. Courts. Today's Law Day forum is the Sidney D. Joseph Memorial Forum on the Bill of Rights, made possible by a special gift from Nina Joseph. We thank you for your support. Our community partners for today's program are the Cleveland Metropolitan Bar Association and the Legal Aid Society of Cleveland. We thank you for your support. We also want to recognize the presence of all of our friends from the Maltz Museum of Jewish Heritage and some of the winners of their annual Stop the Hate essay contest. Thank you for your partnership. Thank you, Ms. Clarke. Thank you, ladies and gentlemen. This forum is adjourned.
Thank you. Thank you very much.
For information on upcoming speakers or for podcasts of the City Club, go to cityclub.org.
Production and distribution of City Club Forums on IdeaStream is made possible by the generous support of PNC and the Raskin Family Fund, with additional funding from Cleveland State University, Robert Conrad, and the Payne Fund.